Hi, y'all, and welcome to tonight's live stream. Two young girls go missing and then are found murdered in Delphi, Indiana. Richard Allen is accused of killing Abigail Williams, 13 years old, and Libby German, 14, in February 2017. He is just 8 weeks away from his trial for murder. And then 70 days of the investigation into Libby and Abby's murders, 70 critical days at the start of the investigation, just poof, disappears. That's the claim of Richard Allen's lawyers. They say the prosecution managed to lose 2 of the most important interviews. And then they found out that that wasn't all, that a full 70 days of interviews are gone, and there's not even a list of who exactly was being interviewed then. So the defense wants the entire case against Richard Allen dismissed. What are their chances? How is this going to affect Richard Allen's trial? That's what we're going to be talking about tonight. So welcome into the stream. Our first 5 in the stream were Bama Queen, Drew P, Jeb Jackson, Patricia Marie, and Planetary Healer. So a special shout out to all of you and a welcome. Glad you are here. And I am, oh, good. Okay. So it was just checking to make sure everything was good. If the state has indeed managed to lose 70 critical days of investigation interviews with no corroborating record, that would be, as far as I've ever heard, just unprecedented. Several extremely important briefs got filed over the weekend in the Delphi murders case on what could be a very game-changing issue, at least on appeal. And we'll talk about all of that. There is right now going on a hearing in the Delphi murders case. There was hearing today. There will be a hearing tomorrow. I would say that what's come out of the hearing has been a little confusing, and that's probably, there's no TV, so it's just people's reports of what's coming out. My understanding is that today's hearing was spent on the state's motion to amend the charges and sort of quickly dismissing a few requests by the defense, and then looking at whether or not Richard Allen's lawyer should be held in contempt. But the court is going to hear the motion we're going to talk about tonight, as I understand it, tomorrow. So you'll be in the know, and you will know what these motions are and just how very, very high the stakes are. So first of all, I do want to say a big shout out and thank you to Squinting Cat for gifting 10 Lawyerly memberships. Thank you. If you want to receive one of those, you have to go in and turn on the ability to receive memberships. Maybe Marlon could put that in the chat for us, kind of how you do that. But you have to actually turn that on so you can receive that. But thank you, Squinting Cat. I really appreciate that. So our plan for tonight is going to be this. We're going to talk about what's the sudden rush in this case. We're going to talk about the destruction of evidence issue. Then we're going to talk about a very unusual, unique motion filed by the defense, the motion for parity. And we're going to talk about what happened today with the amended charges, because the judge did amend the charges against Richard Allen some. And then we're going to, if we have time, we'll do a little brief overview of how trial is going to work. We may save that. So let's start with what's the sudden rush and why is everybody suddenly moving so fast? The answer is that the trial was moved up by 6 months from October to May. And here's the reason. As a defendant, you have a Sixth Amendment right to a speedy trial if you're being accused of a crime. And you can understand why if you just think about how unbelievably abusive it would be if the government could just throw you in jail and then just never get around to your case. And you just stayed there waiting and waiting and waiting, never convicted, never even tried, just sitting in jail for life. And that would obviously be extremely unfair. Our Constitution says that you have a right to not have that happen to you. It's just not how we do things. But a speedy trial can be difficult on everybody because it's hard to get ready that fast. So a defendant is allowed to waive the right to a speedy trial when the defendant would rather have more time to get ready. The defendant doesn't have to waive the right to a speedy trial, but can waive the right. Now, a great example of two defendants who took different routes is Lori and Chad Daybell. And they're accused of more or less the same crimes, killing or conspiring to kill Lori's children and Chad's wife. But Lori Vallow Daybell insisted on a speedy trial, and Chad Daybell did not. Now, Chad Daybell will be covering that case, will be going to trial April 1st. And the court separated the trials because they were heading in different directions. One wanted a speedy trial and one didn't. Now, Lori really got the better end of that. We will cover that on one of our next videos when we get started on some of the differences between Lori's trial and what's going to happen in Chad's trial. So back to Richard Allen, though. Like Chad and Lori, Richard Allen has been sitting in jail. And his attorneys dropped a request for a speedy trial. And under Indiana law, that's like strapping rockets onto your trial. So, or onto the entire case, I'll put it that way. So he filed his request March 6th, and the court has 70 days to try the case. So now trial is set for May 13th through the 31st. So now let's get into the enormous issue of the day, the destruction of evidence. And it's a very bombshell kind of emotion. Richard Allen's lawyers are saying that the state is missing 70 days worth of interviews. We're going to look at the motion that they filed and we can talk about it together. It started, I wouldn't call it small, but it started with just 2 interviews being missing. And then according to a filing by the defense over the weekend, it's way bigger than that. So we'll cover all of that. Let me take you through it. I'm going to go ahead and add this to the stage. This is the motion to dismiss, which is how the defendant phrased it. What the defendant wanted is for the court to say, hey, this evidence is missing. The entire case will be dismissed. That's a really big ask. That's really not very likely to happen, but we'll take a look at it. Moves the court to dismiss the charges against the accused for destroying exculpatory evidence. So dismissing the entire case, a murder case at that, really big ask. Not going to happen in this case, I don't think. But that doesn't mean this isn't going to have very enormous consequences, and we'll talk about that, including on appeal, and we'll talk about how it might. So the defense has unearthed significant evidence that third parties named Brad Holder and Patrick Westfall were involved in the murders. And in fact, we heard about those too when we went through that really large motion for the Franks hearing that was done by Richard Allen's lawyers that went into the details about what he believes happened and who he believed might have been involved in killing Abby and Libby. Brad Holder, if you might remember, his son had actually dated and recently broken up with one of the 2 girls. And so and he was involved in the Odinist religion that Richard Allen's attorneys believe is behind this entire murder and what happened to the 2 girls. So we'll keep reading. An FBI report memorializing an interview of Brad Holder contained within the document are these words. The below is an interview summary. It is not intended to be a verbatim account and does not memorialize all statements made during the interview. Communications by the parties in the interview room were electronically recorded. The recording captures the actual words spoken. Also in discovery, the defense found a document dated February 19th, 2017 that appears to memorialize an interview of Patrick Westfall. The report itself does not indicate whether the interview was recorded, although the defense would expect that standard procedure would require video or audio recording of the statements. I'm going to make this a little larger. Okay. So what they're saying is that the interviews that were missing, and this is just the first, as I said, of 2 different briefs, but were of Brad Holder and Patrick Westfall. They were extremely significant in the brief that the defense filed. These are not just low level, not all that involved, not even that relevant people. They were integral to the entire brief that the defense filed, blaming other people. And so the defense is saying these were much more likely suspects. And how do we know? Well, you went straight for them and started interviewing them. That's how we know they're that critically important. How could you lose this? So let's keep reading. On September 8th, 2023, the prosecutor communicated in a letter that there were no audio or video interviews of Brad Holder or Patrick Westphal available. And explained, if you'll go down a little bit further to the highlighted part, due to a DVR program error discovered on 9/20/2017, all recordings up to February 20th, 2017 were recorded over. There is no detectable audio found on this drive. I mean, this is already bad, but loss of evidence is a significant issue that a defendant can talk about at trial. Even if the case doesn't get dismissed, it definitely matters because every witness can be asked, wasn't it true that you interviewed these people? And then you are unable to even find the audio. So you can't tell me what they said. They may have admitted to it. You wouldn't, and you didn't write it down. Isn't that possible? All of those things can be asked. And there was nothing to there. The explanation is just that it's gone. It's entirely gone, written over. And trust me, it's going to get worse. So let's keep reading this one. Experienced defense lawyers fully understand the significance of comparing and contrasting the accuracy and credibility of one's video audio tape statement with that information which is represented by law enforcement officers in police reports or summaries. So they're saying, okay, there may be a summary of one of these two witnesses, but that's not the same thing as having the actual words that were said by the witness. And you can see why that would be, because you can't really cross-examine somebody with somebody else's description of what they said, because then they're free to say, oh, I didn't say that. They must have misunderstood. And what's happening here is they're saying that they may claim that they were misunderstood. I can't pin them down with exactly what they said because you don't have the transcript. I'm not allowed to hear their real words. On August 30th, 2023, following depositions in which the state of Indiana and law enforcement learned that the defense believed Brad Holder to be an actor in the murders, law enforcement finally re-interviewed Holder for what is believed to be the first time since 2017. So a full 6 years later. While in 2017, according to the memorialized report, Brad Holder told law enforcement that he never met Abby Williams, who was purportedly dating his son. His story changed in 2023 when he talked to law enforcement. In 2023, Holder told the interviewer at the 3909 mark, I barely even knew that girl. I met her once. Therefore, one material and highly relevant contradiction exists. It's therefore plausible that many more contradictions would be available to the defense, but for the state's intentional or negligent failure to preserve all the evidence. So that length of time, 6 years, is a really, really long break. I mean, it's easy to forget things over that length of time. That makes it really hard to know. Is the witness forgetting having met the girlfriend? Is he remembering now? Is he trying to cover up? It's hard to know what exactly has happened because of that length of time. And the defense is saying we've got no really effective way to cross-examine because we don't have the transcript to refer to. It has also been discovered that former Rushville police officer Todd Click reached out to Prosecutor McClellan in an attempt to bring to his attention the existence of an 85-page report summarizing the investigation that revolved around Brad Holder, Patrick Westphal, and other affiliates. This letter, which landed on Prosecutor McClellan's desk via certified mailing on May 1st, 2023, was not discovered to the defense until more than 4 months later on September 8, 2023. And only after the defense disclosed in depositions that they were aware of the Odinist ties to the crime scene and investigation. And that's the allegation, is that these two men were, in fact, Odinists. So the defense lawyers are saying, this looks really suspicious because this is not the first time that you've had some problem with getting us information related to Brad Holder and Patrick Westphal. And that feeds into the defense argument that there's been a cover-up. Now, this next point is of extreme significance. In more recent discovery, Defense also located a prepared search warrant application to AT&T for data contained on Brad Holder's and Patrick Westfall's mobile devices. Each application states that Holder Westfall is a known member of a religious sect and elements of the murder have potential religious significance. The information being requested is relevant to an ongoing criminal investigation. So the defense is saying, okay, the state clearly thought there could be a religious connection. So all our talk in our brief about how this seemed to be religious Odinist symbols and runes that were on the girls, you thought that too. It wasn't just our thinking that. You, the state, thought that. And furthermore, you went so far as to actually draft a search warrant. So it's not that these are just two people and they elected not to get data for them because after interviewing them, they didn't seem to have anything. They even went to the trouble of drafting the documents so they could get their data. And they're saying, okay, it's just really unlikely that you've interviewed them, you drafted to get their documents, and then both of those things just disappear. The warrant that you were going to send out, you just never sent, or the subpoena, and then you never have, or you don't have available any interviews for them. What are the chances that all of those things are going wrong at once with these two men? That's the defense argument. It defies logic that law enforcement would conduct forensic examinations of so many other phones in its investigation, yet ignore the phones of Brad Holder and Patrick Westfall, who were viewed as suspects within 3 days of the murders and interviewed by law enforcement, who then prepared search warrants for those phones. These suspicious facts further call into question the circumstances surrounding the destruction of key videotaped statements of Holder and Westfall, if it ever existed, and support Richard Allen's motion to dismiss all charges filed by the state of Indiana. So the defense has some good points here. It does look bad. And so I think that this will be an important issue on appeal, but this gets worse or bigger, however you want to say it. So let's go ahead and take a look at what happened next, because over the weekend, the defense amended its motion. And here's what they are now claiming. The state of Indiana provided two undated reports never seen by the defense. The first report provided some detail as to how the state of Indiana explained that certain videotaped recordings between February 14th, remember the date the girls disappeared was the 13th of February. So these are immediately following the disappearance and then the finding of their bodies, February 14th and February 20th, 2017, which would include Brad Holder's interview, were erased. Therefore, that request has been satisfied. So they're saying we understand now. They don't say necessarily that they accept it, but they understand how exactly this got erased. However, the other report details how all videos between April 28, 2017 and June 30th, 2017 were also lost. This is news to the defense, as the defense was unaware that certain videos did not contain audio. Was aware, but was unaware that videotaped interviews between April 28th and June 30th of 2017, again, this is in reasonably short time frame after the murders, were missing. This is most concerning. Additionally, it appears to the defense that the report is incomplete, as it details attempts to recover the lost interviews, including purchasing some type of equipment from China to assist in recovering the lost interviews. However, that is where the report ends. It is unknown whether the equipment from China was ever purchased or if an attempt to recover the missing interviews was attempted. There we go. So, as I said, this is significantly larger than what had been said before. The state is saying that it lost all of the videos from April 28th to June 30th, and they don't even have a list of whose videos were lost. That's probably the bulk of their initial investigation. That is a long period of time. It was within a month and a half of the time of the murders for then a 2-month period, May and all of June, a little bit of April. And they don't even know whose they lost. And they must have been concerned about it because they went to some lengths to try to recover it, buying this equipment from China, but it appears that nothing happened. It's astonishing to me that there wouldn't be some, I mean, the FBI was involved. Surely they have a copy, surely some backup. They're just, how could it be gone? It just, that boggles my mind. It would be appalling. Anyway, let's keep reading. Based upon paragraph 5A2 above, the defense requests the court to compel the state of Indiana to provide the complete report of law enforcement attempts to recover the missing videotaped interviews. Yes, that would be a bare minimum. Tell us what was done to recover that. And I'm just going to say, we don't know the state's response to this. We have a response from the state, but it overlapped, was filed on the same day that the defense filed theirs. So they weren't truly responding to this new allegation. So we'll learn about what their response is over time. And they may well say that you're totally wrong. We never lost 70 days. You misunderstand. Here it is. Who knows? But if all we're doing right now is reading what the defense has said, knowing that the state hasn't really responded to this exact allegation. And may I say, too, the judge is not posting written documents to the court docket and not allowing cameras in the hearing. So a lot of this is difficult to pull out of the hearing and to sort of understand what's happening there. But these are just seismic accusations. 70 days of interviews. I'll read this last little bit. Again, it is extremely concerning to the defense and Mr. Allen that potential exculpatory witnesses and statements are apparently forever lost, and not even a log of which witnesses were interviewed exists. Furthermore, it is very disconcerting that the defense just learned of this lost evidence, and only upon request of the defense of such a report, and more than 14 months after the defense should have learned of this lost evidence. Totaling the missing days of interviews, February 14th to 20th, and April 28th to June 30th, would show that the state of Indiana has lost 70 days worth of interviews and claims to have no ability to fully account for who was interviewed during those 70 days. Wow. I truly am just sort of flabbergasted about this. This is amazing news. At least with the first two missing interviews, we knew how many interviews there were, and there was at least a summary. The defense points out a summary isn't as good, and that's absolutely correct, but at least there was something, and there was evidence of what was missing. But what we're hearing in this motion is that there isn't even evidence that would show us what exactly is missing during that time frame. So the prosecution and the judge really need to realize how significant this is. I mean, the public needs an explanation for this, because even if Richard Allen got off, let's say Richard Allen was proven completely innocent and he has no one is prosecuting him. He walks away. He's declared innocent, but they know someone else did this. This could affect the ability to prosecute anybody for these crimes, for really heinous crimes of murdering two young girls, just taking a walk on an afternoon in February. It's truly amazing. I mean, this is significant. This is very significant. All right, let's take a look at the state's response. And this is the state, it was very brief. The state said, for instance, the state recently became aware that 4 interviews in 2017 were recorded on an iRecord device and had not been uploaded and attached to the ISP video recordings in evidence. These recorded interviews of Becky Patty, Mike Patty, Ron Logan, and Daniel Pearson were located by Detective Harper and have been immediately made available to the defense. Prior to November 1st, 2023, the absence of these recorded interviews and discovery was not known to the state. Wait, you're supposed to be responding to this, and now this is even more information that was missing. It gives the defense yet another argument that things were not turned over. And besides that, even if you turned over 100 pointless, useless documents, but not the only one that really mattered, then it hasn't been done properly. So let's take a little bit another look at these last 2 points the state made. that during the course of this case, the defense asked the state to re-interview certain witnesses, and the state has done so and provided the interviews, which is somewhat confusing. Are they saying that the defense has known for a long time about the missing interviews? That would really shock me, both based on what they said and also because I would think they would have been complaining about it already, because this really would be a significant matter. So number 3, one hard drive is missing interviews from February 14th, 2017 through February 20th, and one other hard drive contains video interviews without audio. The defense has been notified of the missing data and the events which led to the corrupted or lost files. The state is at the same disadvantage as the defense. That's actually not true, though, because the state is not the entity that has the constitutional right to a fair trial. That's the defendant. But let's be realistic about this, right? There is just almost no chance that the state, and I'll go ahead and pull out so I can talk to you. I'll remove that and make this bigger. Okay. There is just almost no chance that the judge is going to dismiss the case against Richard Allen over this. That's a really large ask to dismiss, to go all the way from murder charges to a free man, never charged with any of this, because 2 interviews were destroyed, or now more than that. So it would not be a surprise for the judge. In fact, based on the history in the case, I would be surprised if the judge did dismiss it. But now Richard Allen has a couple of available options that he did not have before. First, of course, he can ask the detectives who take the stand about the missing evidence. I mean, at a bare minimum, it looks very sloppy. And second, at least in my state, there are options of doing things other than dismissing the entire case when evidence goes missing. The court doesn't have to choose between doing nothing and dismissing the case. The court can do something in the middle. For example, the state can charge the jury, saying, and this is true in my state, I can't say what's true in Indiana. You should presume that the court could tell the jury, you should presume that the evidence that was lost or destroyed was adverse to the party that lost or destroyed it. Or could say something like, if you find that the evidence was lost through the negligence or gross negligence of the state, you may conclude that the missing evidence was adverse to the state, was negative to the state. So the jury could presume that what's missing is missing and it would have hurt the state. That's what the statement to the jury could be. And it would be presumed to be bad for the state. At least that's how a court could do in my state, and I can't say in other states. I personally think that the jury absolutely, if all of these facts are true, and I definitely want to hear from the state, but if all of these facts are true, then the jury probably should be charged here, probably would have to be charged here. I'm talking more from a justice standpoint and not from any knowledge of Indiana law. But I am curious, what would your opinion be on this? So if you're a member, give us some emojis that you think fit this. And if you're not a member, then just write your opinion in the chat or in the comments. I'm very curious. And I want to thank Becky for the super sticker. Thank you, Becky. And Mitt Spunky, I want to thank you as well. Thank you both. So the third motion I want to talk about now is a really weird, unique motion I have never seen before. I think that they probably are the inventors of this motion. It's called a motion for parity. And it's an interesting motion because basically what they're saying is the prosecution is getting lots of resources and money and experts, and we're not. And how can Richard Allen be fairly treated if he's not given the same amount of money? Now, we don't have a response. This came in late from the defense, so we don't know what the prosecution will say, but I'm sure they will say that this is the sort of behavior, this is the sort of thing that the judge is allowed to control. The judge is allowed to make choices within this. She's made reasonable choices, and what they were asking for was a little bit crazy. That's probably what I think the prosecution will say. But let's talk about exactly what it is that they are arguing. And so they said, to balance the scales of justice, Allen asked that the prosecutors working for the state be required to pay out of their personal finances for investigative services, evidence processing, expert fees, as the court's recent order has effectively reduced Baldwin and Rosie, that's the defense lawyers, to a position where they are required to personally advance those expenditures for Allen's defense. So there is, I would say, zero chance that the court is going to do that, but it was kind of funny. They're saying, look, we're having to pay all this out of pocket. How about you just make a rule? It's even for everybody. The prosecutors do that also. Now we get into what they really want. Alternatively, Allen requests that this court prohibit the state from offering any testimony or evidence at trial related to, and they name the 3 pieces of evidence that are worrying them the most: the bullet found at the crime scene, which supposedly matched a gun at Richard Allen's home, the digital data collected by law enforcement, or Allen's alleged confession. They're saying, okay, fine. If you won't let us have experts to counter these big points, then just keep those points out. I would say probably zero chance the court will do that too. So in the alternative, finally, Allen requests that he be granted approval for expected expenses necessary and proper to defend himself, the less contentious and proper remedy to address the inequitable balance of resources, which will lead to an unfair trial if allowed to persist. So he's saying, okay, would you just pay us already? At least pay for our experts, pay us. Let's get moving on that. And they go through a few examples. I'll just give you a couple. Matt Hoffman, a retired fire chief, has been working for them for $15 an hour. The court allowed it not to exceed $6,000. Well, he's worked more than $6,000. So they're saying they have to pay him out of pocket themselves, and that's pretty difficult. So attorney, and this is probably one of the biggest, Attorney Rosie submitted invoices for $51,000 and he didn't get paid. Attorney Baldwin, and both of them represent Richard Allen. Baldwin was paid twice. Now, it took him sending multiple emails. It took 4 months one time and 7 months, 3 months the other time, but at least he got paid. Rosie is saying he's gotten paid nothing. He has a $51,000 bill and they not paid him the first dime on it. And Attorney Rosie, so, okay, just said that. On February 24, 2024, defense counsel filed a verified ex parte motion for a hearing on funding for experts. And they're saying the court gave us some money, but it didn't give us as much money as we needed. There were several things that they wanted and asked for. They wanted a confession and let me flip over to this so I can tell you all of these things that I had down. So give me just a second. Sorry. So one of the things they say is they got initial consults, but then they weren't allowed to keep using the expert and they needed more than that. They wanted a firearm tool mark expert and they were allowed to do a consultation, but they wanted that expert to stay on board and to continue to help them. The same with a digital forensic expert and a clinical psychologist. They wanted somebody who would continue with them, and the court didn't give them enough, just gave them an initial visit and then no more funding after that. And they're saying, you know, the experts for the prosecution are being paid and they're getting them longer term. Defense counsel also requested funding to hire a confession expert. Now, this is kind of interesting because one of the arguments the prosecution has made is, look, Richard Allen confessed. After he was in prison, he actually confessed while speaking to his wife. And they're saying we want a confession expert to educate counsel and possibly the jury on the impact solitary confinement has on individuals accused of crimes, particularly in relation to the voluntariness of a confession made in those conditions. So they wanted an expert to say, and I bet this would be hard to get in. They wanted an expert to come in and say, all right, he was kept in solitary confinement and deprived of everything, and that's why he confessed. I don't know how they would make that leap, but they were looking for an expert who would say that. And they wanted an independent forensic pathologist about issues related to the crime scene, things like that. And the court declined the request as being unsupported. Of all of them, that would probably be the most important. I'm surprised that that one was denied. And then they say, look, Carroll County has paid $2.1 million to prosecute Allen, can't we have a fraction of that to defend him? And even as this motion was being prepared, the state filed an amended exhibit and witness list identifying no less than 3 new and not previously disclosed experts, one on tool mark, one on Odinism, and one on blood patterns and stain analysis. And they frankly have a really good point that they need some parity on the experts. I don't know exactly what they asked for, but the judge will probably have to open up the purse strings to allow them to have some additional experts. And they just argue due process of law requires some balance here. There has to be some parity between what we get and what the state gets. And the appointment of experts for indigent defendants is left to the trial court's discretion. That's what I was saying at the beginning. The trial court is going to get to decide this, but at some point it's going to be deemed not fair. And they're saying when there's this much disparity, it's not fair. So we need you to go ahead and approve payment for experts. And by the way, go ahead and pay the attorneys too. Okay, let me pull that out so I can talk to y'all again. So this one, I've never seen a motion for parity before, as this was called, but it's an interesting motion. And I want to thank Doris Miller very much for the super sticker. Thank you, Doris. So all of these motions I think, will be denied by the court, but I think several of them have legs when it comes to appeal. And I think in particular, the questions about just missing evidence, if that really proves to be true, I think that's going to be a significant issue, not just for prosecuting Richard Allen, but anyone else, because he was accused, and we'll get into that now, what the actual counts against him, because the court allowed the prosecution to amend it. There were 2 counts of murder while committing or attempting to commit kidnapping. He already had those charges. The prosecutor wanted to add 2 counts of murder and 2 counts of kidnapping, saying that's a closer fit to what we actually said in the charging information that we filed with you, court. And the court said, I'm going to let you add 2 counts of murder, but I'm not going to let you add the 2 counts of kidnapping. So anyway, he will now be facing 4 charges, all for the same thing. There's not really a significant change to anything that's occurring. And I'll show you real quickly. I'll add that back to the stage and show you the statute. This is the murder statute, and now he'll be charged with both 1 and 2. The second one he was already charged with, kills another human being while committing or attempting to, and it would be kidnapping in his case. And number 1, now charged with knowing or intentionally kills another human being. And I don't frankly see how it could have been anything other than that. It seems like those fit in the same way, that given the charges against him, I think the prosecution is correct that really makes sense in this particular case. So if you have any questions, if you would put those in the chat. I'm going to be going back to that in just a minute. There were some other motions that got denied today, at least as the report came out. The defense had asked that the prosecutor be dismissed from the case, and the court refused that. Asked the judge to recuse herself, which was really kind of pointless because the judge had already refused to do that. It had gone up to the Supreme Court. The Supreme Court said, you don't have to recuse yourself. So it was going to be a really, really tough sell, and the judge didn't do that. And of course, the judge refused to postpone the contempt hearing against Richard Allen's lawyers. So let me take a look over here and see if y'all have any questions. Oh, I see one already. I forgot to say, if you would put question marks at the beginning, and then I can spot it more easily. So I see Michael asking, how was St. Patrick's Day? It was good. Very good. Nothing dramatic here. I know a lot of people celebrate that very big. In Savannah, Georgia, that's a huge celebration, but not a huge celebration. For us, anyway, we've never done anything wild and crazy. Let me see. I'm looking for questions. I may have I may not have gone far enough down, or maybe I just answered everything you had and not one single person had a question, but that seems pretty unlikely knowing this crowd. Y'all have a lot. Why didn't Constance wants to know, why didn't they report this sooner? And I definitely can't answer that. If Constance, you're talking about why didn't the defense complain about this sooner? In that most recent motion, they said that this was new information to them, that they didn't know this before. And they had an explanation at various points, like, oh, this was told us on this day, and 2 days later we read the motion, things like that. So I think their answer would be they didn't know this. They had no information to this effect before. It was a big surprise. But more will come out. And I would really curious what the state has to say about this, because they may say the whole thing is nonsense. Okay, wait, there was another question. All right, I am missing. Oh, here we go. Marianne wants to know, how are defense attorneys supposed to cross-examine people? What? Only the people the prosecution wants on the stand. This is not acceptable. It's definitely the case, because if the prosecution were to put on the stand these people who were not implicated in the end, they were interviewed, but the prosecution decided not to prosecute them and instead prosecuted Richard Allen, Richard Allen's team would be very much hampered if the original interview was missing. I mean, that is a significant point. And Squinting Cat likes the name, I think, of someone else. I'm moving quickly. All right, I'm looking for questions. If we don't have a couple more, I will go ahead and close this out. Oh, here we go. Annie K. Does any of this lost documentation infer a possible cover-up to the point of a strong appeal? I don't even think, Annie K., that it has to infer a strong cover-up to be to the point of a strong appeal. And this is... obviously, it would play into what the defense has argued. The defense has said this looks like a cover-up, and a lot of people were involved, and they have Odinist guards over Richard Allen, and they made up, they kind of forced him into confessing. He never was guilty. They just wanted him to take the fall while they protected the Odinists who had actually committed the murders. So that cover-up theme is supported by this. But it could be just negligence, just a mistake. They just accidentally deleted all of this and they just didn't have it. Even that would be significant. You don't have to be, at least it does depend on the state. So I could be wrong in Indiana, and it could be different for Indiana criminally than it is civilly. They could have different rules on that. But in general, the loss of evidence is deemed so significant that even if you didn't mean to, it can make a difference, and it can be something significant, because the recognition is, if the evidence is gone and it's your fault, maybe you ought to bear the brunt of not having that evidence. Maybe you're the one who has to bear the problems that come from the fact that it's gone, because it was your fault. It's your fault that it's gone. To me, that especially makes sense in a criminal context where the state has lost evidence. But we will see how it all falls out. But I think it definitely could be an appellate issue. It seems made for that if the judge won't do anything. And I doubt seriously that the judge will make any changes based on that. So Sonia is wondering if this means someone doesn't want Richard Allen to get a fair trial, losing evidence. It plays right into what they said. Michael asking about exculpatory. That means something that would tend to make you less guilty or look less guilty, as opposed to inculpatory, which would make it more likely that you're guilty. So it's the opposite of that. Last question or two. Susie Q wants to know, is this a case where the judge tried to get the defense attorneys disqualified or expelled them? Yes, it is. Yes, it is. And that was, boy... that, honestly, you should go back, and we did some videos on that. That was some crazy right there. That was a very, very interesting series of events where the judge sort of pushed them, told them that if they didn't resign right then and there, she was going to head into the courtroom where TV cameras were waiting. The one and only time TV cameras were allowed in. She was going to head into the room, and she was going to announce that they were being fired, that she was not going to allow them to continue to represent Richard Allen. So one resigned, they kind of resigned, but then they didn't really resign, all of which went up to the Supreme Court, which said both of these guys are back on the case. That was a mistake. Meanwhile, they moved to recuse the judge, saying she's biased against us. And the Supreme Court said, nope, everybody, we're going back to where we were. Let's just try the case, which, as you can see, is not really happening. So there, that is not entirely the case. Anne Moschdiel wants to know, could the possible witnesses be re-interviewed to try to recover those parts of the evidence? Yes, that could be. There are a couple of problems with that, Anne. The first is that it's been so long. So what you remember 4 days after something happens and what you remember 6 years later is probably going to be pretty different, but it could happen. The bigger problem is they said, according to the defense, there wasn't even a list of who was interviewed. So who do you go interview? If they don't know the answer to that, then that's an even bigger problem. All right. One more question, and then let's head over here and see. Oh, thank you, Eileen. I appreciate that very much. And Tom23. Thank y'all both very much. All right. So last question, and it will be from, how do I say that? SD Trekkie Girl. Will I continue to cover the case? I hope so. As long as people are interested, I will, because I find this absolutely fascinating. This case is just nutso in lots of different ways. And I see that Hopester is asking me about Kent May Winnie's trial, when it is and whether I'll cover it. Again, Hopester, if people are really interested in it, I find that case really interesting. And certainly we covered all the way through Michelle Troconis. So I find it even more questionable what Kent May Winnie's involvement was. And I'm very curious what the state has to say about that. So I would be interested in that if other people are as well. So we'll just kind of wait and see. But this particular case is the Delphi case. Really, really interesting. I see Girl Ryan saying, am I just uninformed, or is everything that's happened with this case very wrong? I know, Girl Ryan, I feel the same way. How could this just be missing? How could the Odinist part never have been revealed? How is all this secret? I really remain mystified by this case. I find it absolutely fascinating and a little bit crazy. So, as you know, we go Monday, Wednesday, and Friday at 7 p.m. Eastern. So I will be back with you on Wednesday at 7 p.m. Eastern. I can't wait, and I will see you then. Prosecution showed it to jury, and so you can get a pretty good look at it too. Red, blood-like substance on it. He said it was even wet and leaking everywhere. That was a quote. Zip ties, a razor blade. Why were these items there? And in the back window is a bobblehead of Alec Murdaugh going back and forth.